Welcome. Thank you for attending today's webinar on an overview of the Genius Act S1582 and to get a sense of the impact it's going to have on the credit union industry in particular. For those of you who do not know me, my name is Henry Meyer. I, I am the solo practitioner and owner of the law office of Henry Meyer, which started about 3 years ago. I'm dedicated to helping credit unions and mortgage banks with a wide variety of issues, including typical transaction activities such as drafting contracts and that type of thing. Prior to starting my own firm, I spent about 15 years at the New York Credit Union Association, where I was ultimately the senior vice president and general counsel. In that capacity, I was in charge of a wide variety of areas ranging from providing general legal advice to credit unions to helping to carrying out the legislative advocacy responsibilities of the association. The service I provide, which is absolutely crucial, I believe, for those of you in a leadership position in your legal department or compliance department, is to try to keep you 6 months to a year ahead of regulatory, legislative, and legal developments. That's the difference in my mind between reacting to legislation and legal developments and preparing for them in a way that either minimizes the negative impact or allows you to maximize the advantages that come with the increased flexibility. Believe it or not, there are some certain circumstances where regulations create opportunities for growth. The stablecoin legislation is a perfect example of precisely this type of situation. Over the next 3 years, when this gets fully implemented, we will have a system in place that will allow credit unions to issue stablecoins through CUSOs. That will allow credit unions and give them the flexibility to understand that they can provide custodial services for stablecoin issuers, and that custodial services could include safekeeping services as well, such as protecting passwords. Finally, all this is going to be overseen by either the NCUA or, in most circumstances, with federal approval by your state regulatory authority. Very interesting, Henry, but why does this really matter to me? Well, first, as I mentioned, this is going to be the first and probably not the last of the cryptocurrencies to become subject to a regulatory framework. Right now, that regulatory framework does not exist. Okay? It allows non-depositories to issue their own stablecoins. That means that, like it or not, you're going to be competing against non non-banks such as Facebook, which has talked about this for years, for for your members' money, because now they can make put it into a Facebook stable coin as opposed to your your accounts. Okay, then it's going to think of the stable coin not only as a means of currency, but as a separate payment rail. Okay, so that means that it's going to be able to create a system where they might be able to bypass and probably will be able to bypass, they being merchants, interchange interchange fees for debit and credit cards. Okay. Then there's also the issue that, like it or not, is coming. Okay. The major banks are going to issue their own stable coins. And this is going to be one of those areas where it works out the way I think it will. Your members will increasingly be expecting all of you to have similar offerings. Okay. It also means that there are potential growth opportunities with your credit union. Like I've said, you can get involved in this new field by providing custodial services or safekeeping services. Okay. Finally, an example of how much this is going to become part of the industry, Fiserv is already debuting a bank-friendly stablecoin. So it expects this to be around for a while, and there's going to be competition for you in terms of who you're going to work with to get that stablecoin underway when you feel it's time for your credit union to do so. So when I talk about being 6 months to a year ahead of the curve, one of the things that intrigues me is the timing of how this process is going to fold. It's going to unfold. We are. This is not a typical regulatory situation where we can say, okay, nothing exists today. In X number of months, we're going to create this new product or this new mandate. Stable coins and cryptocurrencies in general are, of course, being used by the trillions, by the trillions in our worldwide phenomena. What this bill does is create a regulatory framework at the end of which previously legal activity will be considered illegal, excuse me. Okay? So basically the act takes effect the earlier 18 months after enactment or 120 days after final regulations are issued by the primary federal stablecoin regulators. In other words, you may see this done quicker than just 18 months, but NCUA has a year to put this in practice. And the reality is that these regulations and the framework that's going to go with it are going to be quite time consuming. As a matter of fact, I think one of the issues we're going to have to look forward to is how exactly is NCUA going to cope with these requirements and creating a whole new regulatory framework for overseeing this new product, precisely when it is cutting back on staff. Okay. But ultimately, as I said, the key point to keep in mind is that come January 2028, only regulated stablecoins will be legal. And that means by that time, we will have the regulatory framework in place to both supervise and authorize the issuance of stablecoins by depositories and non-depositories. So what are we dealing with? And I just wanted to provide a very general overview of the technology involved, not as an IT person, obviously, for those of you who know me, but because there are some key concepts that this statute codifies for the first time. Remember, this is technology that has been around for more than a decade now in terminology, and this is the first time that is going to be put into a federal statute, again, because states have already done this type of thing, many of them have, and we're going to be using a regulatory framework of the federal government. So here are some of the key concepts, though, behind what exactly I'm talking about. Okay, first of all, you're dealing with a digital asset when you're dealing with any type of cryptocurrency, and certainly when you're dealing with um, with stable coins. Then, how do I know that I have that? Well, you create what's called a digital wallet. Okay, a couple of days ago, I was fortunate or unfortunate enough, depending on whose side you're on, to go see the Mets against the Cleveland Indians. Okay, I paid for that using the MLB app. They sent me an electronic signal which represented my ticket, and the days of me using a physical ticket to get into the stadium are over. This is much the same technology, excuse me, much the same approach, except now instead of using um, so instead of having a physical wallet, you're going to have an electronic wallet that's going to be available on your phone or computer. So what is this? What's so special about this network? Well, if I want to send money through if I want to pay for let's say my Amazon Prime product using their stable coin, because I'll bet you right now they're going to have one. What I would do is simply say, okay, I'm going to send out a signal to the merchant that I want to use the digital ledger network to pay for the product using the stable coin. So first it's going to check, okay, is it in my wallet? If it is, that transaction is going to go over what's called a digital ledger network. Now, the key about this to understand, folks, is this is one of the key points. These digital ledger networks, they are not banks or credit unions. They don't have to be. Okay. They could be normal people with the computer technology to join the network and do what's called validating the transaction. You've probably heard of the concept of a blockchain. A blockchain is nothing but a digital representation that someone on a given network has in fact validated that Henry Meyer really does want to send money to, in my example, Amazon. Okay. That transaction is put on the blockchain, and in theory, as of right now with current technology, it's immutable. So we don't need to go with a bank to make sure that, hey, does he have money in the bank? Because if he didn't have money in the bank, if he didn't have that currency in his electronic wallet, that transaction would never have been confirmed. So that is the key points I want you to keep in mind. It is a digital asset which is not tangible. It uses digital ledger technology in which the traditional banking system can and is bypassed. Obvious but crucial question: how is a stablecoin different from a traditional dollar bill or traditional currency for that matter? Okay, it isn't backed by the full faith and credit of the United States government. Okay, it's not. Crucially, there's no interest or yield that can be given for owning a stablecoin, and they can only be used to facilitate purchase and payment of products. They are, or I should say, primarily used to facilitate purchase and payment of products. And the statute itself says that there are certain anti-tying prohibitions that we're going to be talking about that go with this new authority. And the basic idea behind those anti-tying prohibitions is you cannot make, if I am a merchant, the acquisition of a product contingent on using a specific type of stablecoin to facilitate the transaction, nor can I prohibit you from using a certain type of stablecoin to facilitate the transaction. Within that realm, though, there are many things you could do, in my opinion, to create incentives for the use of stablecoins. And that's going to be one of the areas we're going to have to look at. As I've said, this technology has been around for years. The key part with this legislation is that for the first time we are seeing on the national level, as I said, it's been done on the state level for a while now, we are seeing these key terms codified and brought into the mainstream. As a result, if you draft contracts, and you may want to consider using this and mining this statute, the Genius Act, for some of the key terms you're going to be using as you get more and more involved in the space. Okay, but what is a stablecoin? Here are some of the key points that I want you to keep in mind. I'm not going to read the statute verbatim, but I do want to pick out some key provisions of it. Okay, it's designed to be used for means of payment or settlement. Okay, it is not a security. Okay, it is as the issuer, you are basically representing. You are representing that it can be redeemed or repurchased for a fixed dollar amount. And the way you're going to do that is you're going to make sure that there is enough money backing it up, tacked away against the amount you issue, so that you do have the ability to redeem the electronic assets upon request. In fact, in the statute, you are representing that that as an issuer, for instance, if you're an issuer, that you will maintain or create the reasonable expectation that it will maintain, that your stable coin will maintain a stable value relative to the fixed value of a currency. Isn't a stable coin? Well, it's not. It can't be a national currency. So I know there are some countries where where they have in fact I think it's El Salvador, where in fact a stable coin is now being used or cryptocurrency is being used as a form of national currency, but not in this country. Okay. It does not include a deposit and it is not a security. Okay. Two quick points about that because they're both important. Just because you might be using digital ledger technology doesn't mean you will be using a stable coin. Crucially, there are many banks that are now offering people their account on cryptocurrency because it might come in useful, for instance, for bookkeeping purposes. Okay, and that type of thing, particularly for businesses. Well, simply because you're using digital ledger technology doesn't mean you're offering a stable coin and that you have to go through this process of getting regulated. Okay. It doesn't include a security because that's always been one of the great debates in this space. In the absence of a regulatory framework, people have argued, no, when you use cryptocurrencies, the price varies so widely that these are more akin to securities than traditional currencies. Now, we've talked about this a little already, but this is first and foremost a digital asset that is based on the ability to solve a cryptographically generated algorithm. And that's the key. You're going to need the computer power within that network so that people have the ability to say, hey, I solved this algorithm and I can vouch for the fact that this is in fact a valid transaction emanating from that electronic wallet I was talking about. A digital ledger first of all, it has to be public. And another thing is, as I already said, it uses distributed ledger technology, which is technology that can be used to bypass the traditional banking system. Think of it this way: instead of having simply one gatekeeper who's already looking at the books and putting in the checks and balances, everyone on that digital ledger network is effectively an auditor, and everyone gets the same copy of the audit report as soon as a new change is made. So let's say your credit union or bank either is thinking about issuing its own stablecoin or has enough dealings with someone who does or invest in them enough so that you want to understand the framework, regulatory framework. Well, if you were to issue a stable coin, you will be subject to the primary oversight of either the federal NCUA in the case of credit unions, of course, or state, or generally a state regulator. A couple of key points about that. Okay, you have the option of being subject to state oversight if, in fact, a determination is made that from the federal government that the state regulations are comparable to the federal regulations. In other words, there's an interesting preemption issue going on here, and there's an interesting state-federal balance taking place under this legislation. On the one hand, many states have offered these type of licenses for years. For instance, New York has for a decade and a half. On the other hand, they do not want a situation where institutions find themselves subject to more severe restrictions on what they can do with their stable coins based on whether they are state or federally chartered. Therefore, state regulators, to the extent they want to offer these products, are going to have to get approval on a periodic basis from the federal government. But now, if you issue less than $10 billion in stable coins, so it's not the asset size, it's how much you issue, you will generally be subject to the oversight of a state regulator, and if you're a federal credit union, obviously the NCUA. Once you get under that $10 billion threshold, over that $10 billion threshold, then you're going to shift. If you're a state chartered, you'll be shifting from the primary oversight of the state entity to the primary oversight of NCUA. But you follow the regulations, they're promulgated, you follow them, and you get approval. Okay. Well, among the things you're going to have to do, most important ones are going to be making sure that you have adequate reserves for one-to-one redemption based on the value of your stablecoin. Um, you're going to have a clear redemption policy, which is available on your website so that people know exactly what they have to do if they want to redeem their stablecoins. And you will have monthly reserve and reporting requirements as well as accounting certifications. In other words, there is a lot of oversight that goes with providing these and issuing these stablecoins with an emphasis on making sure that the collateral that is being used to back up the currency is widely known, widely understood, and that the information is widely available. Also, remember that you are, even though you are a bank or credit union, it is your subsidiary that is offering these stable coins. So that subsidiary is going to have an independent obligation to comply with the BSA AML mandates. Now, the interesting thing about that is that those mandates are going to include the responsibility to know your customers. Now, think about that. One of the real attractions of stable coins and cryptocurrency in general is the privacy afforded by the product. Well, the reality is that how does that square with CIP requirements? We're going to find that out in the regulations. That's why, in my opinion, the legislation is largely what I call a placeholder at this point. We're really going to have to see what the regulations say to understand how we are going to apply the BSA and AML requirements in the context of OFAC and Bank Secrecy Act requirements. Another key area that we're going to have to hash out a little with regulations is going to be consumer protections. What we know from the statute is that there can be no misrepresentations with regard to the fact that these are not guaranteed. Payment stable coins are not backed by the FDIC or the Share Insurance Fund. Okay, there cannot be any product tying arrangements, and you cannot give interest payments or yield for these assets. You cannot give interest or yield on these assets. And public companies require federal approval if they are non-depositories before the Amazons of the world even begin to offer these products. So let's say you decide that offering and issuing stablecoins isn't something you're interested in doing. You don't have the bandwidth for it. Totally understandable. Well, you're still going to be able to provide custodial or safekeeping services. This is crucial because unlike the FDIC, for instance, and the OCC, HCLA has been very tepid and cautious with regard to allowing credit unions to engage and in these fields. As a result, there is one legal opinion or letter to credit unions that permits them to provide services with a third party where they simply refer members who might be interested in getting custodial services to a provider of such services. Now you're going to be able to do that directly. Okay. So you're going to be able to offer custodial services as well, but that's going to be extremely tricky. As you go through this list, the one thing I want you to keep in mind is that since we are dealing with an asset which is ultimately intangible, there are going to be certain issues that go along with that the custodian is going to be in the forefront of trying to figure out from a legal standpoint in terms of who do I give this money to? Okay. For instance, most importantly, this statute provides that the claim of any customer with respect to a stablecoin shall have priority over the claim of any other person, okay, other than a stablecoin holder. Well, that seems to be telling me that anytime there's a bankruptcy, we better find out if any of the creditors holds any stable coins, and if they do, how much, because that person's going to get priority or with just about anyone else in the bankruptcy context. And another thing you should keep in mind, there was already some great information available from the OCC about custodial and safekeeping services that are already being provided by banks. As a matter of fact, Rodney Hood, when he was acting head of the OCC, reissued these opinion letters to underscore that banks have the authority to engage in custodial and safekeeping services because they have been doing this for 5 years. For those of you interested in this, you seek out those opinion letters. They're very easy to find. To say OCC opinion letters on stablecoin services, and they should come up. I want to thank you so much for taking the time to listen to me today and to watch this presentation. I will be sending out a copy of the PowerPoint for you folks to review on your own time. And I also would encourage you, my contact information is back in the first slide. If you're interested in having additional questions or have additional thoughts about this area, and it's an area where you may want legal representation or consultation, please feel free to give me a call anytime. And again, thank you very much for taking the time to learn about this very important topic.